A humane touch of the law is essential for ensuring that the law serves the needs and interests of all people. It requires a willingness to be empathetic to the unique identities of people, with a commitment to accessibility and fairness, and implementation which is grounded in compassion and respect for equality and diversity. When the law is wisely applied and interpreted in the hands of judges, women and men who have a feel for social reality and compassion in the application of law, it takes a step forward towards realizing justice. But when the law is wielded without principle, it can carry the burden of arbitrariness. For the judges and lawyers, and indeed for all of us as citizens, the constitutional path is reflected in the values of the preamble: fraternity, dignity, liberty, and equality. These parameters provide the beacon for the unity of our nation and the stability of the social fabric. The relations between the executive and the judiciary on the administrative side have to be marked by a sense of robust constitutional statesmanship. All three arms of the state, the legislature, the executive, and the judiciary, are engaged in the common task of nation building. But on the judicial side, the confidence and faith of the citizens in the judiciary lies in a fierce sense of our own judicial independence. The legitimacy of the judiciary as an institution depends on the faith which we command of our citizens. And that faith is determined by one factor and alone, which is whether we become the first and the last choice of access to the citizens in times of distress and need. Constitutional statesmanship, above all, whether it is on the administrative or on the judicial side, requires deliberation. It requires dialogue, not public grandstanding.